Hello and welcome to the June 2022 episode of My PIP Monthly. My name is Amber Rouse Holloway and I'm a partner here at our Troy office. Our June 2022 topics included case law discussion. I did want to do something a little bit differently from the prior topics. Normally I do a case law update, but this month I kind of wanted to talk about these two interesting cases. First up will be the case of the estate of Michael Wells by Gregory Wells, personal rep, v. State Farm Fire and Casual Insurance Company, and Joseph Nara. Then we will talk about the Booker v. Hartford Casualty Insurance Co. case. Both of these are unpublished opinion, and just for reference, Secret Wardle represented Hartford throughout the entire appeal of the Booker v. Hartford Casualty Insurance Company case. And then we'll move on to trending topics in PIP litigation. And I wanted to discuss kind of like an update of the case evaluation, sanction amendments, and how that's being played out. The sanctions portion is being played out in litigation post the removal of sanctions as of January 1st, 2022. First up, the case of estate of Michael Wells by Gregory Wells, the personal representative v. State Farm, and Joseph Nara. Here, the appellate court affirmed the trial court's decision that State Farm was entitled to summary disposition in plaintiff's deck action. The court ultimately determined that plaintiff's pleadings showed that the subject accident was the reasonably foreseeable direct result of furnishing alcohol to minors, and therefore not an occurrence of the accident under the homeowner's insurance policy. I did want to give some background on this case. So plaintiff's decedent was Michael Wells, along with a Jonathan Manolios and Emmanuel Malage, were involved in a single vehicle accident, unfortunately. Plaintiff alleged that Jonathan Manolios, or defendant Joseph Nara, operated the vehicle recklessly after being intoxicated by drugs or alcohol furnished to them at the home of their friend, who was also a teenager, Gregory Bobchick. Manolios and Nara were also of underage. Plaintiff further alleged that the Bobchicks knowingly provided the alcohol to teens at their home, which caused the accident and plaintiff's damages. At the time of the accident, the Bobchicks had a homeowner's insurance policy with State Farm, and State Farm was to pay liability limits for damages where the insured was liable for bodily injury as a result of an occurrence. The word occurrence meant accident in the policy. After settling the automobile claims with the Bobchicks, a consent judgment was filed in favor of plaintiff, was entered against the Bobchicks to settle plaintiff's social host liability claims. As indicated, the plaintiff alleged that the Bobchicks furnished the alcohol to Manolios and Nara, and that was the result of the crash that killed plaintiff's decedent. They said that that was the occurrence requiring State Farm to pay the consent judgment under the homeowner's insurance policy. Plaintiff filed the deck action for a ruling that State Farm had to pay the social host liability consent judgment under the policy issued to the Bobchicks. Defendant State Farm denied the policy issued to the Bobchicks covered the accident and would not defend the social host liability claims, and they cited MCL 436-1701 and MCL 750-141A. State Farm subsequently filed a motion for summary disposition on the basis that under Michigan case law, furnishing alcohol to a minor is not an accident as defined by the insurance policy, but an intentional act that carries risk of harm introduced by intoxicated driving. At the hearing, the trial court granted State Farm's motion for summary disposition on the grounds that providing alcohol to minors is not an occurrence covered under the homeowner's insurance policy. Obviously, plaintiff then appealed, and on appellate review, the Court of Appeals applied this two-step analysis where it interpreted the insurance policy. 1, does the general insurance agreement provide coverage for the occurrence? And 2, is the coverage negated by an exclusion? And they cited the case of Auto Owners Insurance Company v. Harrington. The panel went on to discuss the burden of proof as outlined in the Supreme Court decision in the case of Hensner v. Frankenmuth. And in that case, the insured had the burden to prove coverage, and the insurance company had the burden to show the applicability of an exclusion. After the panel's review, they came to the conclusion that the pleadings pertaining to the social host liability contained in the consent judgment indicated that the Bob Chicks intentionally furnished alcohol to the minors. The furnishing of the alcohol to the minors created a risk of impaired driving, which resulted in plaintiff's damages. The pleadings showed that the crash was a reasonably foreseeable occurrence because of the deliberate act of providing alcohol to minors, and thus not an occurrence or an accident. So because it was a deliberate act, it was not an accident, and therefore not an occurrence. It was concluded that the plaintiff's claim of coverage under the Bob Chicks policy was unforeseeable, and there were no facts to support recovery. Therefore, it was proper to grant the motion for summary disposition in the trial court. Next up, we have the case of Booker v. Hartford Casualty Insurance Company. This was issued July 16th, 2020, my apologies. As we all know, Michigan law requires that a named insured have an insurable interest to support a valid automobile liability insurance policy. An insurance policy is therefore void if there is no insurable interest. And it must be noted that the insurable interest must belong to a named insured on the policy. Although the insurable interest must belong to a named insured, an insurable interest need not be in the nature of ownership, but can also be any kind of benefit from the thing so insured, or any kind of loss that would be suffered by its damage or destruction. The term any kind, obviously, is extremely broad. I wanted to give a brief background on the facts of this case as well. Here, the plaintiff was injured in a motor vehicle accident driving this 2004 Cavalier. He was the sole owner and registrant of the Cavalier. Plaintiff was a part-time handyman who, in the course of purchasing the automobile insurance policy, created a corporation so as to qualify for a commercial policy so that he could get a lower rate for insurance. The plaintiff listed the entity as the Arthur Booker Handyman Services, and he was the sole named insured on the policy covering the Cavalier. He obtained this policy through Hartford, who again was represented by Secrets Wardle throughout litigation. After the accident happened, Hartford denied plaintiff's claim for PIP benefits on the grounds that Hartford did not insure the plaintiff or anyone in its household. Plaintiff alternatively sought the PIP benefits from homeowners, which issued a no-fault policy to plaintiff's sister, whom he lived with at the time of the accident. Plaintiff filed suit against both no-fault carriers, as well as the agent and agency who sold him this commercial policy. Owners claimed that Hartford was higher in priority because it insured the motor vehicle, and discovery revealed that although plaintiff incorporated his handyman business, it kept no books, had no accounts, and only generated about $900 in gross revenue over a 4-year period. Plaintiff also had not done any work through the business for about a month prior to the accident, and he testified that the business never got off the ground. Hartford then moved for summary disposition in the trial court, citing the Barnes v. Farmers case, which held that an individual is injured while operating his own motor vehicle. Coverage for that vehicle had to be in the name of at least one registrant in order to satisfy MCL 500-3113A. Because of the lack of any discernible corporate activity, Hartford argued that the named insured could not have been the owner of the 2004 Cavalier. Alternatively, Hartford argued that its policy was simply void because the corporation had no insurable interest in the 2004 Cavalier. So here we are. The trial court did agree with Hartford on both points and dismissed the case. The finding was fatal to plaintiff's claim against homeowners as well. Interestingly enough, while this case was on appeal, the Barnes was overruled by the case of Dye v. Insurance, so that the only coverage for the 2004 Cavalier was in the name of a non-owner or registrant was no longer fatal to the plaintiff's claim. However, if the named insured had no insurable interest in the vehicle, the policy would simply be void and would still disqualify plaintiff from the PIP benefits. Again, in the appeal, Hartford maintained that it did not because the corporation had no real-world existence and therefore would not suffer any loss from damage or destruction of the Cavalier, that it was not in the order of priority and owed no benefits. Hartford argued that the corporation existed only on paper as an artifice to qualify for a lower commercial premium. The Court of Appeals disagreed, finding that the corporation had an insurable interest. The Court of Appeals held that the Booker Handyman Services Company was not the title owner of the vehicle involved in the accident, but they did have a pecuniary interest in the vehicle. Booker testified at his deposition that he used the vehicle for carrying tools around or cleaning products in the trunk of it, used for business purposes, maybe 4 times a week. His testimony was very clear that he used the Cavalier on all jobs. He also testified that it was purchased for him and the business. Ultimately, the court held that the Hartford's policy was not void for lack of insurable interest, and the panel held that the plaintiff was entitled to PIP benefits from one of the 2 carriers. However, the record did not allow for the panel to decide the issue on appeal, so the case was remanded back to the trial court to determine whether Hartford had priority. Ultimately, the panel's finding that the corporation had an insurable interest in the vehicle does raise some questions, because generally an insurable interest must be pecuniary. Given the record in this case that the plaintiff made no attempt to differentiate between the extremely limited revenue generated by the corporation and his own personal assets, the panel seems to have a tension with the long-standing principle in Michigan that separate corporate entities will be respected. And as we know, generally a corporation is treated as a separate legal entity from its shareholders. We have plenty of case law that supports that. However, it seems that the panel may have overlooked the fact that the corporation needed to derive some pecuniary benefit from the 2004 Cavalier in its own right. And also, I'd like to briefly discuss, for trending topics in PIP litigation, the case evaluation sanctions rule post January 1st, 2022 amendment. As we all know, effective January 1st, 2022, the Michigan Supreme Court instituted some significant changes to the case evaluation rule. Most importantly to litigation and trial is the elimination of the penalty sanctions for a party who rejects the case evaluation award. Previously, the rejection of the award would expose the rejecting party to sanctions, including payment of the other party's attorney's fees, unless the rejecting party improved its position by at least 10% at the time of trial. So this aspect of MCR 2.403 was eliminated, totally eliminated as of January. It should be noted that the court rules were silent in the elimination and in the footnotes of the order that how this change would affect cases that are pending before the rule change, or cases that were filed right before the rule change but litigation took place or case evaluation took place after January 1st, 2022. Generally speaking, we've seen the Michigan Court of Appeals say that new and amended court rules apply to all proceedings and actions brought on or after the effective date, as well as pending cases, unless the application of the amended rule would not be feasible or would work injustice. And that's the case of People v. Teets. This is an unpublished opinion. Also, some published case law on this issue. Here we have the rule in Michigan is that changes in judicial procedure apply to all further proceedings and actions then pending. And that's the Prisoli v. Mullins case. And you want to also take a note of Lindsay v. Raymond, and that's citing the case I just cited, as well as citing the Davis v. O'Brien case, which indicates that the norm is to apply newly adopted rules to pending actions unless there is reason to continue applying the old rule. And as to Michigan court rules that address this issue, a court may permit a pending action to proceed under former court rules if it finds that the application would not be feasible or would work in injustice. So again, it's still pretty much up in the air. The court rules do provide some guidance. Case law does provide some guidance, but it seems as if this should be taken by a case-by-case basis and argued in whatever way benefits your case. But there seems to be support for each way, published support for each position that could sway the trial court. And that is all I have for you today for the June 2022 episode of My PIP Monthly. Please feel free to contact me with any questions and or concerns. And for anyone that's still listening, last month's publication, we were having some email issues. So it appears, I found out later that someone did email me and I did not get their email, and they gave me a call and asked me to follow up. So please, if I have not responded to you as of last month, that was a total oversight, and we were having some email issues just in that period of the very quick period of the publication of last month's episode. So please feel free to call me. Again, my number is listed, or email me again if you have any questions and or concerns. Thank you.